Good morning. Are you Destiny Williams?
Yes, ma'am.
And Miss Williams is here. Two cases, cause numbers 12-14477 and then 19-32216. Previously in court, pled true to counts. Looks like 1 through 6 or 7. The numbers are kind of pled true to failing to report, failing to appear in court for judicial review, failing to maintain employment, failing to pay, and fail to complete anger management in each of those cases. I've received an updated report. Has everyone received that report?
We have.
Are there any additions or corrections in that report?
Judge, my only addition, if I may, with the court, obviously we understand it's your decision. I have spoken at length with Mr. Burbank about it, spoken at length with Ms. Robinson about it. Obviously, the court will see the age of these cases, especially the one that's from 2000.
Well, they're both only being held, I only have one
Correct.
choice, right?
Right,
Revocation.
right.
I can't extend or
No, and
continue.
that's not what we were asking.
Okay.
We were proposing based on the age of everything, and I believe Mr. Burbank has some testimony to offer with respect to the fact that she was gainfully employed at all times. She admits that she didn't report. I think she's obviously had the problems on probation, but due to the fact that what frustrates me is that she's never been in trouble and she's going to become a convicted felon real quick. She's spent considerable amount of time on these MTRPs over the holidays, et cetera, and we have all discussed asking the court to possibly consider allowing that and maybe a little bit of additional time if you feel necessary to serve as a sanction and just allow her probations to expire out without giving her the convictions due to the fact that these were not aggravated offenses and the age of them is obviously up to you, but that's just something we have proposed.
I also have, for the record, Mr. Burbank's office sent over several letters yesterday, one from Ms. Williams that I've read. And so, Ms. Robinson, you're here today. Thank you for being here. Had some positive things to say as well in the updated pre-sentence report. What are your thoughts on that proposal, Ms. Robinson?
I agree.
You do?
If I can fill in just a little bit.
Sure.
I think she's worked at every restaurant during this period of time. She's worked at McDonald's, she's worked at Cracker Barrel, she's worked everywhere. Whataburger. She has 5 kids, right?
Yeah, 5.
5 kids. She was currently and still, we reached out to Black Bear Diner before she was picked up for this incident. She accepted a kind of a promotion to be a manager there. So she's worked her way up from working there to manager position. And my understanding is that it's probably still available. Her mom is here too. And she would just testify.
At this point, the violations are admitted. The question is institutional. Should the court enforce revocation mechanically or weigh rehabilitation against the permanent consequences of a felony conviction?
We have attempted to try to verify the W-2s, but because she's been in here, we've done the best we can in reference that she has been employed, and we provided everything to the state. And I would ask that you consider all that in the decision.
Well, Ms. Williams, I really appreciate your letter, more than some that I get, because it really did seem very sincere. And I appreciate that you have come to realize kind of what started all of this back at, 16, right? And so that self-realization is big. It's taken a while, but it's big. And so a lot of times I get letters and I can tell someone else probably wrote them or it was not from the heart, and I appreciate your letter and I appreciate what everyone's saying here today. And based on all that I will allow the dismissals of the motions to revoke. I'll sign those when it comes through. Do better for you and your kids. so that you're not back in here on anything else, okay? All right, good luck. Yes, ma'am.
Maybe it's,
Yes, sir, thank you.
What occurred in this courtroom was not an act of leniency in the abstract. It was an exercise of judicial discretion within structured limits. The violations were real, the record was clear, but so too was the broader context. Employment, family responsibility, time passed in the absence of new criminal conduct. Courts operate at the intersection of rule enforcement and institutional purpose. Probation is not designed merely as a tripwire for failure. It is intended as a mechanism for supervision and reintegration. When revocation becomes automatic, the system risks substituting procedure for judgment. When discretion is used carefully, it preserves the credibility of both law and mercy. The dismissal of the motions to revoke does not erase the past. It reflects a determination about future trajectory. A felony conviction would have imposed structural barriers, employment, housing, civic participation, that extend far beyond punishment. The court weighed whether those long-term consequences advanced public safety or simply compounded instability. In that sense, this decision illustrates a central tension in modern criminal justice. Whether institutions exist primarily to record failure or to recognize progress. The authority of the court lies not only in its power to sanction, but in its capacity to distinguish between persistent defiance and delayed reform. That distinction is where law becomes governance, where precedent, discretion, and human behavior converge.